Good afternoon, everyone, and I'd like to thank you for joining us today. Last week, Acting State Controller Kevin Walsh released a report on the review of sick and vacation leave policies. The report reviewed the policies, ordinance, contracts, and survey results of 60 municipalities with a population over 10,000. The law on this issue is very vague and conflicting, and we think that the controller missed an opportunity in the report to review the existing conflicts between the statutes, the state agency, and court interpretations. Recognizing that this is a hot topic, we quickly put together today's Lunch and Learn. Therefore, there is no CEU credits for this webinar this afternoon, but this is only the beginning. We'll be holding additional webinars in the coming months, have a conference session dedicated just to this issue alone, and there'll be a detailed article in an upcoming New Jersey Municipalities magazine. With us today, we have League Labor Relations Counsel Joe Hannon, who is a partner at Genova Burns, and the League's labor consultant, Matt Watkins, a retired manager, former director of the Division of Local Government Services, and a former member of PERC, Public Employee Relations Commission. Before I turn it over to Matt, I want to do a couple of quick housekeeping items. First off, as you come into the session, please mute yourself. We will be monitoring any questions you have. Please put them in the chat box. We will be monitoring the chat box to answer the questions. If time allows at the end, we will do a Q&A on screen. If not, we'll try and respond to the questions via email in the coming days. Again, this is informational only. This shouldn't be construed to be any legal advice. We, again, and I'm sure Joe will say this numerous times, to check with your municipal and labor attorneys for interpretations of your individual contracts. So at this point in time, we do have a hard stop at 1 o'clock. So I'm going to turn it over to Matt Watkins.
Lori, thank you very much. And everybody, welcome to this quickly put together session to address the confusion that I think is generated with the report. And we've all seen that in my work with the Labor Advisory Service from the League. Last year when this report came out, I had a number of phone calls that I fielded. So we thought that it would be best just to have a quick session to talk about the issues that the report brings up. And I think the important thing is that you understand, first of all, we're providing you some suggestions. None of this is legal advice. You shouldn't go back to your governing body and say, Matt Watkins said this, so we should do it. Or Joe Hannon gave us advice that we should take this action and act on that. In every situation here, it's imperative that you work with your labor attorney or your attorney to talk about those issues and to see what is unique to your municipality. There is no the law is vague, and so we want to try to give you some advice. So Joe is going to go through the report a little bit in a summary form and talk about some of the litigation, some of the legal aspects of this and where it's vague. And then I'll come back on and talk about approaches that those of you that are municipal managers out there should take or could take with your governing body to try and explain this, because there's always anecdotal information that runs around and out there and then leaves everybody confused. So with that, Joe, I'll let you take over and then I'll finish up. And then if we have time, we will do a Q&A session when Frank hands us questions. So Joe.
Thanks, Matt and Lori. Good afternoon, everybody. And, thanks for, blocking out the time to go over this important topic that municipalities face. I've been dealing with for, a good part of the past decade. So yeah, I'll share the screen in a second, but what I'm going to do is I'm going to run through the report in summary form about the items that are brought up, because I think that'll be a way to weave in, some of our analysis on what we see on these laws, because I think in dealing with them in practice, and you first had the 2007 laws, and then you went to the more, I guess, stringent and broad 2010 laws on the accumulated sick leave, is it left questions for municipalities at how to deal with it. One thing I want to say at the outset, and it's probably some of the issues that municipalities are dealing with on these issues, and why the report shows certain municipalities are not compliant with certain areas of these laws as per their interpretation. And first, by no means are we going to go and do a case study on any one municipality. I mean, we're not going to name a municipality throughout this whole session. That's not what this is for. This is for to help guide you along in the process of analyzing your contracts, your ordinances, your policies, seeing if you're compliant as best as you are, and where there are questions, at least raise them so you could do the analysis that Lori and Matt has spoken about, because it's important. Listen, anytime you go into negotiations or dealing with an issue, it is a time to kind of reopen your contract, take a look at it, almost let it breathe, see what's out there. There are provisions that remain in a contract for a while. They were negotiated back in the 80s or whenever they were negotiated, and they're there, and it's always an important time to kind of go back and take a look and see what you have. So that kind of is where you would go from here. When you look at it, what we're dealing with is payment of sick leave and accumulation of vacation. And I think where a lot of the confusion comes up is this. First of all, sick and vacation leave are both negotiable issues in and of themselves. I mean, if a union were to come to you in negotiations and say, most people have tier vacations, let's say. Maybe they max out for the highest employees at, let's say, 25 days. If a union were to come to you and say, we want that 25 to go to 28, you're not going to file a scope of negotiation petition at PERC to remove it, because that's a negotiable item. Same thing with sick days. When you talk about compensation in and of itself is negotiable. So you're talking about issues with, if you take in separate chunks, in and of themselves are negotiable issues. That's how a lot of these, first of all, that's how all these provisions regarding payment of accumulated sick days, being able to carry vacation time, being able to pay out maybe a vacation, unused sick bonus, what have you, the things that were talked about in port, that's how all these things evolved and they came in there in the first place. When these issues, I would think most of these issues came into a negotiated contract or into some kind of policy, they were permissible at the time and to be negotiated. So I just want to leave that at the outset as to how some of this stuff happens and where it is. It's a reaction to things that were negotiated, these 2007 and 2010 laws. They're a reaction to what the legislature felt was excessive payments for this time. And listen, I've been at the negotiating table before, Matt has before as well, and the issue of sick time has come up. And a standard response I have when and I've heard it from unions is if about sick time is, well, people, if you're not going to pay for it, I'm talking way back, then people start using sick time. And it's always a philosophical debate of, and I look at that and I'm like, I thought, almost facetiously, but also seriously, is, I thought sick time was insurance that you would get paid in case you get sick. And the fact that you haven't used your sick time is actually a good thing. I mean, that's a win, right? I mean, at the end of the day, it's a win if you're healthy, if you're not out sick. So these are things that have played out over time. So I just leave that as the backdrop before we go into it. I'm going to share my screen so that I get this PowerPoint up. And if I screw it up, then I'm just not going to show it because of my technology. But let me see if this works. Are you guys seeing it? Okay. All right,
Yeah,
good.
it comes through fine.
I saw a yes from Matt, so that's good. Okay, so let me go into this. I want to see how to get to the next. Okay. All right, so hopefully this continues to work because, okay, now I got it. All right, so the report, I'm sure many of you have read it, but people might not have. I mean, this came up, you get something from the league about, we're putting together a seminar on an issue. You realize in your positions that it's important. So the Office of State Controller, I'm not going to go through all the state controller's duties and what have you. We don't have enough time, but initiate a review of 60 municipalities to determine if they've implemented the cost saving measures required by the various sick and vacation leave laws. All right, so what are we dealing with? I've alluded to 2007 and 2010. I'm sure most of you are aware of that. But in 07 and 10, the legislature passed laws affecting certain employees that put limits on when payments for unused sick time could be made and capped them at 15,000. Now, the initial law in 2007 definitely created confusion because what happened there is it provided a cap of 15,000 for accumulated sick leave payouts. Initially, I just remember from practice, a lot of people felt that this was a complete ban on any accumulated sick time payouts above 15,000 for everyone. And it took a little explanation and analysis to realize that, they define the term officer and employee within that statute. And what it came out to, and I'm not going to read the definition, but it only really dealt with higher ranking. The report calls them senior employees, but it didn't deal with your rank and file, your unionized workforce, your majority of your workforce. So the provisions in the law, and you have in a lot of places, school boards, municipalities, you had provisions in contracts where people could have left the municipality with substantial payouts, six figures, what have you. There was no limit, and the 2007 law was opening the door, limiting to certain individuals, but it didn't have the all-encompassing view that I think initially was thought of, or at least some people thought initially, because I would have some clients be like, we can't give anybody. I'm like, well, that's not really what it says. So it's not. So you don't have the luxury of saying that this is preempted by statute and just unilaterally doing it. What you have to do is you have to negotiate it out. I think what this started is a trend towards negotiating in limits on accumulation of sick time payouts at retirement. This started that trend. 2010 cemented it. In that the 2010 law really applied to everybody in the municipality, whether you're civil service or non-civil service, the school district. And that created the situation that you now have today, where if you are hired on or after May 21, 2010, the effective date of the 2010 legislation, they're cited in the report. So, I'm not going to provide sites unless you really need them. They're in the report. You could ask your counsel on them as well. But that provided that limit. Okay. So what I've seen, and I know the report doesn't support that, but you saw a move towards negotiating those provisions into CBAs. Now, I think the one thing the report doesn't say, because I don't think it had to say this, but I think it is true in practice, is that what happened in some areas too, which is a positive for municipalities, is that I do believe, and I haven't done a study, so don't quote me on how many have it, but I know they exist out there, is you've had a situation where unions and municipalities have negotiated a 15,000, a 12,000, whatever cap for everybody. So that's happened in places which has been a savings even above what, if you want to call it a savings, but not paying out as much as what the law initially had, which was open season. So I think that is a positive under that law. But obviously, what's happened is not every not every municipality has done that, and we'll deal with the report a little more with that. And that law basically says that the payment of accumulated sick time is related to when an individual retires from one of the retirement systems in the state. So it's linked to retirement. So certainly when an individual retires, the 15,000 cap is there for those hired on or after May 21, 2010 for all employees, and then June 8, 2007 for those higher ranking employees. That moves forward. The people hired before that really still is no limit. So that's where it gets tricky in contracts and determining when people are hired, and you have to figure that out as to whether you're compliant. The second part of that, and it gets in the report, and I know it exists out there. It was not surprising to see that in the report, is the issue of the payout of the maybe annual sick leave payouts for not being able to cash in for some days. I know the report takes a pretty strong stance that this is not permissible under the law because it's only linked to retirement. And that is what the law says. So there is a provision in there that talks about linked to retirement. The question is does this go to the negotiability aspect of, well, this isn't a payout at retirement, this is an annual payout. Certainly if someone has resigned, leaves to go to another position, and now leaves your employ, they wouldn't be entitled to the payment if they were hired after these dates. And what I'm talking about is always hired after the date, because that's when these come into effect. But the annual payouts and what they do, I think that's, Matt will probably talk about it too. That's seemingly more of an open issue. There has been some decisions on that, which I think municipalities can say that they have a preemptive analysis. I don't think the face of the law itself maybe not as clear on that issue as when you retire. So that's something that I think is still subject to at least debate, maybe some litigation, and I think maybe probably some more litigation, after this report has come out, and seemingly, municipalities may adjust, which unions may say, well, you're violating some provision of the contract. So I think that's a rub that you may see going forward. And like anything else, that's something that I think you have to talk with your counsel about, what your provisions say, who it affects, and is this permissible under the law? But that definitely is a question there. And then also the limiting how long and how much vacation leave employees may accumulate. And again, that dealt with provisions in the 07 and the 10 law about only being able to accumulate X amount of time, being able to accumulate only a year, and having to use that the next year. And I know that in practice, municipalities will have that. It should be limited to that amount, first of all, but then how you credit it going forward when you take vacation leave the next year, are you using your, let's say we're going into 2023 next year, and you carry over 10 days for vacation, let's say for argument, when you do your accounting, if you take your first 10 days, are you counting to the 2022 allotment or the 2023, and then how you moving that going forward? But they saw some discrepancies in how that is dealt with, and is carrying over vacation leave, again, vacation time negotiable, compensation negotiable, are policies violative of the law or not? That's going to be very individual to what your contract says, and the interpretation of the law against that, because there are, I'm sure there's a bunch of ways of how that is, but those are the three big issues there. And obviously the goal was to lower property taxes. That's always the goal in a lot of these things. That's why we had interest arbitration reform with the 2% hard cap. This was all, in that same thought process, in trying to provide some reasonable limits to what's out there. So I talked about the laws. These are the laws themselves. So you do have them there. Here's who's covered by the 2007 law, and the accrual. So I kind of spoke about them in general, about what they provide, so you have an understanding of what's there. But these, it just covers, they're really the same law, just covering civil service, non-civil service school districts. So really, your whole gamut of public employees. And then you have the 2010 laws, which are there, and these deal with the sick leave. And like I said, doing the 15,000 to basically all employees. So you do have all the sites there. These laws apply to every municipality, school district, and county, as well as a lot of other, municipal authorities, your water, sewer, parking authorities. This is a review of kind of what I was saying, but you have it there, is that the 07 law applied to senior employees such as municipal managers, department heads, the really higher up. So it did not touch that many individuals. And then there's a typo there. Obviously, that's May 21, 2010. There's an extra 2 in there, so I apologize to that on the last thing. But we went over that. So again, this is important, and it's an important point to realize when you do your analysis, because the goal of what we're saying today is we're not going to be able to answer I know a lot of municipalities are on, and that's a great thing. We're not going to be able to answer questions for 250 different municipalities, or however many are here, because unless you all have the same contract laws or the same way of dealing with an issue. So the point is to get some of these things to really start the conversation, to give you a better handling of what's out there, and the next steps that you have to do, and just making sure you're compliant or not. I mean, the one thing I would say is don't go through this to say we're definitely not compliant. I mean, take a look at this and then see where you may or may not be compliant. What are the remedies? I'm sure Matt will talk about some of that too. But is it negotiation? Is it just saying, a memo, here it is, this benefit you had no longer is there, and then see where it goes? I mean, that's going to have to be specific to your town, your relationships, and what provisions you feel you may be not compliant with. All right, so again, remember, the date matters. The employees and their data hire matters. To the extent that you were able to do a more blanket provision and you limited the sick time accumulation to 15,000 for all employees, well, then you did more than the law allowed, and that's that's fine. But to the extent where you have tiers, make sure that these tiers meet the provisions that are there. So Lori went through what the Office of State Controller did, and the number of municipalities they selected, all populations greater than 10,000, and did their surveys. What was done in the process? Well, here's why this is important, because what the Office of State Controller did, and it could be, I think municipalities, I read of one today where they said that they are compliant. They didn't look at all the updated information, but just the things you look at: your policies and procedures, your employee handbooks, and of course your collective negotiations agreement is probably the first place you're looking at, just to see what they did. They looked at online database of employees' contracts maintained by PERC, some survey responses. So they did their homework and came to a conclusion. And like I said, whether the municipalities in the survey feel that they were wrongly identified stuff, that's for them to take a look at. But this is what the findings were. So just understand that some of these numbers are substantial as far as what they looked at. So I guess it's eye-opening as far as where do we need to be careful, or what are things that are going to be looked at should my municipality get audited and audited or looked at, or whatever you could say, and how we deal with it. So they said that almost 2/3 of municipalities permit sick leave payments to senior employees that are unlawful under the 2007 law. Okay, so what does that mean? What they're saying there is, by looking at the contracts, that individuals who became senior employees on or after June 8, 2007 are receiving payments upon retirement in excess of 15,000. I mean, that's basically what that's saying. So that's one place you would want to look at. Where are we there? 50, almost all municipalities have policies or contract that undermine the cost-saving intent of the 2010 law. Okay, so I mean, what you're looking at here is are all the things that I spoke about before, the payout of retirement, the sick leave, maybe a sick leave buyback for a certain amount of sick days per year, vacation carryover, is it in excess or not? It's saying that almost every municipality is doing something that isn't quite on board with what their view of the intent of these laws are. Okay. Almost 1/3 of municipalities have not implemented the 07 and 10 vacation accrual limitations. Okay, so the question is, what is meant by that? I wasn't necessarily clear in reading the report, and I could look at it again. This has come out, but is it, and this is something you have to do, is it you are overtly violating the law and providing well in excess of it, or is it you have a negotiated provision that you feel meets your negotiation obligations and also stays within the confines of the law? So I think there's probably some gray areas there, and and that would have to be analyzed without making a blanket statement, without knowing the facts of your place. The goals of the 07 and 10 laws may be undermined by conversion and payments for annual vacation leave. I think the vacation leave stuff is, especially with PERC, they really haven't, they've spoken on the sick leave a bit. I think they're going to hear about it more. So there is some kind of headway into the fact that, this stuff, good chance it's, at least some of the stuff is the annual payments might be preempted by that law. I don't think it's settled, but it's out there. The vacation really hasn't been touched in PERC, at least not that I've seen. So that, be mindful of what the OSC says. Should probably see if there's a way that you could, if you're uncompliant, if you're not compliant with what they say, you might want to, at least have a talk about it. So summary of the 56 non-compliant municipalities. This is that breakdown, and I kind of was saying it, but this is how it broke down. More than half, they pay out over 15,000. 40 to 80% pay for sick leave at times other than retirement. Less have sick leave caps that take effect after May 21, 2010. So there's always a question of whether, if you were in the middle of a contract and let's say, you grandfathered people in, is that permissible under law? I think the law is that, if you're hired after May 21, 2010, you need to be in compliance there. But some of them, obviously, and again, I don't know the individual specifics of any one municipality, or could, rehash all the municipalities that were contained within the report. But, what that violation would be could be that, they started with a cap in 2011 and 2015, whatever it may be. About half allowed annual sick leave payouts. 17 to 60 allow for terminal or early leave, so paying for something other than retirement, and bonuses and incentives to compensate employees for unused sick leave. That's a very open-ended question. Bonuses and incentives meaning something other than pay. Maybe if you don't take sick time, you get an extra vacation day or something. Is that violative of the law? I think even the report itself says that's not really, that wasn't really settled, but their view is the intent of the law was not to do it. And I'm sure if that issue ever comes up, that will be certainly an argument that is made at some point. So we've gone through it. Here are the variety of ways that you could be violating, paying over to 15,000, given payouts when an employee resigns or switches jobs, paying every year. I think we've kind of covered that already, but these are just kind of going through the report and what they were saying there. What does that mean? Well, what it means is what you see with a report. It's reported. In municipalities are asked to comply, to come up with a plan for compliance. And, I think one of the things is, how could this be enforced and what the enforcement mechanisms, and that's not really clear of them, but, certainly the tone and tenor of the report is very clear that that these payouts and what have you is a is waste and leading to some of the issues within the state as far as property taxes and what have you. These are some of the principles involved in it. I think we've said it. So what does the OSC require now? The municipalities were directed to develop a corrective action plan, forward it to review by the end of September, the steps taken, and make a recommendation for municipalities with policies that violate the law, their local governments, and the legislature. Basically, these specific, but everybody to kind of take a look and review their policies. This is really where we need to go. I mean, I think from here, it's incumbent on everybody to do this, to do a legal review of their contracts, of your ordinances, to do an independent assessment, and then set up the the game plan of where you go regarding regarding these issues. Let me just stop the share for a second. So that's where the report what it handles and what it looks at, and I've tried to summarize the various issues regarding these cases. I mean, I think there's a couple of things to look at as well. I mean, I know in dealing with negotiations that negotiations always seem to be going on. To the extent that any of you are involved in negotiations right now, it provides almost an easier avenue to look at it and address these issues for sure. For those who are not involved in negotiations, it still doesn't mean that you can't do this analysis and see where you are. Again, I think that there are some things, and I hope I've again, check with your counsel, of course, but I do think there are things that are very clear with these laws, and I think there are things that certainly have to be discussed and analyzed, and probably if you're going to make a move somehow, do you do it by just a memo saying, here's what we're doing, we're making a change, if you feel you're not compliant, or is it an issue that you still feel you have to negotiate? I mean, that's something that will be need to be determined. But this is kind of the universe of what you're talking about: is payout of sick leave upon retirement, payout of any sick leave or vacation leave on an annual basis, and how much vacation you're carrying over. The law is set forth within this within these provisions in the report, in the PowerPoint. Those are the laws you're looking at. There is some case law on them, to go through and see, and may provide some windows of a way to deal with it. But really, when you're what this report should do to all of you is just say, we need to look at it. And I think that it's something that employees will have to know that that's potentially coming, should there be something that they are receiving that that they shouldn't. And then I think a frank discussion and action has to happen to the extent that there is a need to move. But that's going to have to be an ultimate determination made by 565 municipalities. It can't be answered in one fell swoop, because most of these answers aren't as clear cut as they may seem. But it's a moment in time where this has been brought to your attention, and it's important. And just by the attendance today is a good sign, for municipalities, that it's being taken seriously, and municipalities just want to be able to comply. So just go through that analysis. I'll turn it over to Matt. I'm sure I'll have a few more words, but hopefully that at least gets you pointed at least start you in the right direction of where you need to go from here. So Matt.
Thank you, Joe. Thanks very much. Appreciate all that information. There's a lot to digest here. Let me just go into a couple things, and I don't want to repeat anything that Joe said because we're very limited on time. As you can clearly see from Joe's report, this is the law is very vague, and there's a lot of unsettled law on this. So I wanted to kind of approach this, my part of this, and address this to those that are in the administrator manager roles, or at least in charge of getting negotiations going. Back last October or November, and sorry, I didn't look this up, I wrote an article in the League magazine on preparing for negotiations. And one of the key points that I said was you need to go through now, because a lot of contracts are coming up at the end of the year. Now is the time to go back through and look at all your contracts and all your languages, make sure that it comports with the law. And if you want a copy of that article, you can get it on the website, or you can send an email to me at matt@njcs.us, and I'll send you the articles. But I do want to address the nature of this kind of report, what comes back to you and what comes from your governing body, because your residents and your governing bodies see this stuff, and they get, they want to know what's going on. Why are we doing this? It's important that you know the law. I think Joe's, and I'm sure we can work that out to have that posted with the league so you can access it later on. The important part is you say, look, this report, was only 60 towns. As Joe said a number of times, there's 565 towns. We're all different. You need to look at the language in your contracts. You need to do that now. You can't wait. This is something that you have to review now. The issue of sick leave buyback is critical. Really, the law does not allow for it. I know that in other towns that I managed, we had the buyback provisions right in the contracts. And so it's tricky because the law really says you can't do that. So you have to get that out. Now, in the course of negotiations, you're trying to get down to the root of it. Everybody wants to get to what's the raise going to be. And a lot of these issues during the course of those negotiations, things like this with sick leave buyback, get kind of tossed out. The rush to get a settlement, you toss that out. This is where we have to stand firm with the unions and negotiate that clause out of the contract, get it out of there. If you have it in your personnel policies and procedures, get it out of there. It's not supposed to be there anymore. Now, what I always caution people, do not just all of a sudden say, it's no longer there. And the first guy or gal that comes through and is retiring or is leaving, and they expect that payment, and you say, oh, no, we got rid of that. Well, then, if that happens, that's because you didn't tell them. It's very important that you send out the notices and say, effective September 1, we're not doing the buyback, and here's why. Be clear, be open with all your employees to tell them that is changing. In fact, it's required that you provide notice. The other thing is on the vacation caps. Now, my experience and my discussions with towns, we're successful adopting a limit to the carryover vacation. But the problem is, recently, with COVID, a lot of people didn't take vacation because they couldn't. Circumstances were, as we all are painfully aware, they couldn't do that. I've been asked about that issue. What do? You make sure that in the following year, let's say there's a 2-year limit on how much you can carry, the current year and the previous year. They're in excess of that. You set down to the employee, and you have to do this on an individual basis. Sit down with the employee. You need to use your vacation time in the first quarter, whatever that excessive amount is. That's one technique. The other technique is to just pay them out for it. You can't, PERC has already ruled very clearly on this issue. You can't take away vacation because they didn't use it. You know, that euphemistic clause, use it or lose it. That doesn't exist in New Jersey unless you have it in your labor contracts that it is such. But you can't just unilaterally come up and say, well, I told you had to use it, so I'm going to take it from you. PERC has ruled on this several times, that doesn't stand. So push them into using that vacation. Now, what happens if they don't? Then that's when you should institute discipline and make it clear when you tell them that they have to use it, that you will discipline them, but don't you discipline them basically for insubordination. They didn't follow your orders. And so I know in a case that I had, employee didn't use their time, gave them time to do that. They failed to do that. So I ended up suspending her in this case for the week that actually she was over on her vacation time. So vacation time cannot be given away. It can't be lost. You have to make them use it. If they don't, you end up disciplining them for insubordination, and let that go as that. Make sure you give everybody notice. You cannot just unilaterally implement these kind of things. The nature of working with your governing body is important because they get a lot of information, as we all painfully know. They get information from Facebook, which is, I won't comment on Facebook, but you know, they get information from Facebook. It's wrong. It's just wrong information. They see news articles about this. News articles are just wrong. They'll pick up some things and they just will be wrong information. Not saying all of them are wrong all the time, saying it can be there. You need to sit down with your governing body as soon as you've sorted this out over the next, hopefully the next 30 days, sorted this out, where you are, where you stand, and what needs to be done, and then go into closed session, meet with your counsel and explain it to them. Okay, it's the only way you're going to be able to get this ahead of this as soon as possible. Ideally, this could be done in a couple of weeks, and you need to make sure that you do it as fast as possible. So make sure that you also, during negotiations, when this comes up, again, as I said before, a tendency is to kind of push this stuff aside and get to the meat. Don't. You have to stand on this issue and you have to be clear on it. Right now, though, the law is vague, so we're kind of swimming in uncharted waters. Got to be careful. As I've said a number of times now during this webinar, this 1 hour session, make sure you're working with your labor counsel or your attorney, so that you don't do something that gets you into litigation. I think litigation is inevitable in this case, but try to keep yourself out of it. So go through it carefully, but now's the time to act. If you fail to act at this time, and I think there's a concern about this issue because we had so many people sign up for this webinar with only days of notice. There's a lot of concern, so you have to respond to it now, and you have to get your stuff together as best you can. Joe provided a great outline for you, and I'm trying to give you some ideas about how to approach the governing body that, you know, so that you can address this quickly. So we're going to leave the next 15 minutes to ask some questions. I know Frank is there on the league, has been accumulating the questions, and we'll try to answer those as best we can. So Lori or Frank, you want to give us a question that seems to be popping up?
Yeah, hi, this is Frank. So some of the questions seem to be very, very fact specific, so I'll try to root through those. So one of the questions came up when Joe, you were speaking. An employee hired full-time after May 2010, but has a part-time date before May 2010. Do they qualify to receive the sick pay?
I think I'll jump in on this part, and Joe, you may have a different opinion. I think that the way I would view that is it depends on what seniority you've given them. I know that a police officer, sometimes you get this where you say, we'll grant you seniority back to when you started in another town. So I think it's your date as it rates to seniority would be a good benchmark, but I don't think the law is clear on this issue. So, Joe?
I'm
Joe,
sorry, I started talking and said I'm muted. It doesn't really distinguish between full-time and part-time in there, so, I think you could take the most expansive of view of this. I mean, I would think that, it certainly, the part-time hire date, certainly could work under the law, because I don't think, listen, if you're dealing with the 07 law, then I think it's pretty clear, who that applies to. I think the 10 law is pretty open, probably would, it probably would allow for the part-time, but I agree with Matt. I think there is some kind of wiggle room you have, not wiggle room, but just depending on how you classify individuals and how and what that part-time employment means, as far as seniority, probably is a factor you could look at. But as a general rule, if I were to look at it, I would say that there is nothing prohibiting using the part-time date within the law.
Frank, next question for us.
Yeah, so the next question is, does an employee with 25 plus years of service have a cap on vacation and sick time, such as a municipal clerk versus maintenance laborer? And this is in a civil service town.
Joe, you got that? I think it does. But Joe, the law, I think, was clear on that one.
Do you have a cap on vacation time?
Right. If you're 20, if you started before the 2007 or
Yeah.
2010, are you still capped out on vacation? I would contend that you are, but that's my opinion. But
I think, yeah, I believe you are.
yeah.
So
Again, I think if you're not doing that, you should implement that, because and especially with 2007, you're talking about executive, you're talking about unclassified employees, really. Talking about your department heads and things like that. That I think you implement that. Go through a notice process and implement that.
So the next question has to deal with the intergovernmental transfer. So if an employee was an intergovernmental transfer, such as a police officer from another civil service transferred after 2010, are they subject to the cap?
Again, I think it goes back to the part-time issue. I think it's how you rate them as in your seniority. A lot of times, I think, and at least my experience, every case where we're intergovernmental transfers, we give them their credit, we give them their seniority date back to when they started with the other agency. Especially when you get into police and fire, I think that's there. I think you give them that time, and if they fall within that framework, I think, yeah, I think they apply or don't. Depends on how it falls out. But I think it's how you rank them on their seniority.
Yeah, I think that, that would defeat the purpose of the intergovernmental transfer. I mean, I guess that's something that would be open for, a court or something to decide. But I don't, it doesn't accept it out. And I think their hire date would be based on when they were hired.
Right.
And the intergovernmental transfer would kind of just be an extension of that. So I think the initial hire date would still apply. That's how, again, not 100% answered by the legislation itself. And I don't think I haven't run across a case that has interpreted that, but I think that would be a fair interpretation. I think you'd have to kind of look at that a little further, but that would be my reasonable interpretation of it.
Again, I'm going to say, we're not giving you legal advice. We're not telling you what to do. We're just giving you our opinions. This is especially me, because I'm not the lawyer here. I'm telling you what I would do as an experienced administrator with it. You got anybody that takes that advice, go back to your labor attorney and say, what do you think about this? Okay. Frank, next one.
So the next question, the recommendations in the report include identifying improper leave payments for potential recovery. How realistic is it that will be required to claw back payments already made?
I'll
Can
be
be
very,
extremely, it's
Yeah.
extremely tough. I mean, I don't mean to make light of it. I mean, it's always, it's always the issue in dealing with something is, do you pay an employee if there's like if there's a question on a discipline or something, do you pay them and then you can recoup it back? And I just know that it's very tough to go into court and get money back from an employee that's
Right.
been paid. So
I agree 100%. I know you want, a lot of times there's a desire to, but the cost it's going to create for you to try and get that money back, I dare say you would lose all the money that you gets back in trying to do all the legal defense that you'll have to, and the time for the administrator and everybody else's time. I think you end up losing everything that you tried to gain. Bad idea.
So
Frank, next one.
another question, I'll try to, if annual buybacks are prohibited by law, it would seem that a contract could not supersede the law and the matter would not be negotiable. It would seem like a notice to the union that this clause of the contract is contrary to state law and will stop immediately could not be legitimately challenged. Is that correct?
So let me take that first and then you go. I mean, as far as an analysis under perk, as far as does a statute expressly, definitively, and comprehensively, I think those are the words that is used in the negotiability test. Does it do all that and speak on the issue and leave no room for other interpretation? In that case, perk would come back and then say it is preempted. The one thing I caution, with that is, and perk may very well decide that, and that would be the end game. There is, I know perk looks at that very narrowly, that test when they interpret statutes. So if you're a voting member of the commission, you would have a say on that. But if that's how perk rules on it, then I don't disagree with that. I agree with that statement if all the steps are as it comes out. Matt, I don't know if you want to.
I think that I think this is where it gets really unclear and very difficult. I think that you need to look exactly what your language is in your contract and exactly what the law says, and review that with your attorney. And if you want to take that risk and implement that, my only caution to you, or what I think you should do if you're really to take that gamble, not that because it'll be challenged, I believe, just give plenty of notice. Say, as of August, not August 1, but September 1, this is what we're saying, and this is why. Failure to give notice and give it universally to, all employees, I think it opens you up to a challenge that will force you back to the table on it, and it'll just be a disruption. The notification process is very clear. The law wants that very clear, and that's what you need to do. And just do it now if you're going to take that hard stand. And I think just provide the proper notice and give it a shot. Frank, one more question, then we'll wrap it up.
Yeah, so this is a interesting one. Does the New Jersey Earned Sick Leave law, which was recently passed, have any impact on the 2010-2007 law? New Jersey Earned Sick Leave specifically states that employers can pay sick leave.
What we talked about was just, we did say, the sick leave buyback provisions are what the law doesn't allow anymore. In other words, you know, I only use one sick day. So like provisions I had in a contract where that employee didn't use but one sick day, so I can buy back three days of sick leave that I didn't use, or some limit to it. And that's what the law, we think, is pretty clear that you can't do. Payment of sick time upon retirement is, I think, is subject to a cap. And I think you're gonna, that's where it gets a little less clear, and I think is subject to negotiations, but that's my opinion. Joe, you have anything on that?
I think I would add, I don't know if this answers the question, so I apologize if it doesn't. But I would just say, as far as the earned sick leave, is that if a benefit is earned or paid out under the earned sick leave law, which is legislation, then that would be proper. And maybe if that payment, if the earned sick leave law didn't exist, would not be appropriate under these 2007 and 2010 laws. But if it's done under a legitimate legislative authority, then that would be fine. I mean, I don't have the exact example, but I hope that answers the question, as far as, you know, to the extent that it's legitimate under another New Jersey law, then that payment would be legitimate. And, you know, I guess it's another way of looking at that. So I hope that answers the question.
Right. Joe, final comments you want to make?
I don't think anything other than we already said, Matt.
Okay.
You know, I just think that, you know, the purpose of today was to get you thinking about this and get you
Right.
to do an analysis and take a look. And if there are things that you feel are not compliant with the law based on the report, do the analysis. And I think Matt made a good point about, if you're going to do something drastic to change it, notice and communication is important. But do what you have to do if you feel that, you know, you've been maybe wrongly interpreting one of these things. But you know, take your time. Don't panic and rush to a decision right away, as far as, you know, making a determination. You know, it's timely now. It's a good time to take a look at it. But make sure that when you come to an ultimate determination, that you have a clear path. And I think that's what the report and their recommendations is generally telling people they want you to do. So so hopefully that in your attendance today is, I think, the first, you know, exhibit A of your intentions to do the right thing there. So that's what I would leave at. And Matt, if you have a couple of last words, then.
I'll just say thank you to everybody being on here. We're, you know, as far as my work with the League of Municipalities, I am available to you. I can't give advice, but I can, or legal advice, but I am there. And Lori posted my email address. Happy to help. That's part of my work with the League. So Lori, you want to wrap this up, or?
Certainly, Matt. Thank you.
And could I say one thing, Lori?
Certainly, Joe.
I saw, you know, it's tough when you're doing this and presenting and listening and answering questions, is every now and then I see something pop up, and I know Frank was going through questions and someone had something. Will we be answering questions that were in the chat? You know, what we'll do, and Matt, you know, I guess we could take a look at what's out there, and to the extent that we could, you know, respond to people individually over the next coming days, we'll do our best to
Yeah.
do that.
If and to that extent, to make it easy, if those of you that didn't get your questions answered, you just want to send them to me, that's fine, and I'll try and get, Joe and I will try and get back to you as best we can. You know, we're all busy, but we'll certainly try and answer those questions. So, Lori, I'm sorry. Go ahead.
Well, no, that's fine. Thank you, everyone, for attending. I'd like to thank Joe and Matt for taking the time. We do have the hard 1 o'clock stop. This has been recorded. A copy of the recording will be sent to everyone that's on the call, and it'll be posted onto our website. We will follow up with the Q&As as much as we can. Like I said at the onset, this is just the first one. We'll be doing additional webinars in the coming months. There'll be a detailed magazine article. We'll be holding a conference session on it. So again, thank you everyone for joining us today, and keep an eye out for further communications on this. Thank
Okay.
you.
Hear me?